today we have a first in the history of Conduct Detrimental. This is our first town hall format. Usually we'll have one guest, or Dan and I will just kind of, bat around a few different topic ideas in the week in sports law. Today, in advance of the U.S. Supreme Court oral argument in the NCAA versus Alston case, we turn to two of the most prominent experts in the collegiate sports law space, Warren Zola and Gregg Clifton. And I curated Warren and Gregg with Dan's acquiescence because they are, not only two of the most experienced and well-respected lawyers in the sports law space, but they're very good communicators. They've been around for a while. They've seen, I don't mean to say that they're old, but they've been around this for a long time. And, for someone who 5 years ago, I was a neophyte in the sort of the sports law space, I couldn't have come across two better individuals in my ascension to sports law than Gregg and Warren. And, just my first year at the SLA conference, nobody was friendlier to me. And that isn't the criteria for selecting them today. But I remember in advance of my first, my first panel appearance at the SLA, I was like a bundle of nerves. And Warren saw me at breakfast, just so nervous, going through all of my notes. What was I going to say about daily fantasy sports? I didn't even go out the night before. I treated it as if it were a first year final exam. And Warren settled me down, and over breakfast, he said, "Dan, when you come right out of the gate, make sure you underscore and communicate to your audience. Tell them why we should care about this issue. Tell them what's significant about it." And so I'll turn the tables on Warren and ask Warren, can you do the same thing in the NCAA Alston case? Why is this such an important case, and why should people be caring about it?
And thanks Dan for the introduction, and welcome to Gregg and Dan. Nice to meet you. Again, appreciate you guys inviting us on here. And I've known Gregg for decades. He's my second favorite member of his family. His daughter is a student here at Boston College and took my class and did incredibly well. So, and I haven't met his wife yet, so he might drop to 3. But anyways, it's a great question, Dan, as we think about the Alston case, because as we all know, we've been paying attention to the business of college athletics. It's been growing exponentially. You can really pinpoint it back to 1984 in the Board of Regents Supreme Court case that was decided, where the floodgates sort of opened up and many schools began to chase money over education. And as a function of that, over the past 30 heading towards 40 years, people have become aware of the disparity between schools, the revenue being produced, and that has triggered a lot of people to start paying attention to this industry, beginning with O'Bannon in the early sort of 2011, 2014 timeframe. People started to talk about name, image, and likeness. And then the Alston case came by, which is even a broader look at the role of the NCAA, capping compensation, antitrust laws, the Sherman Act, and whether or not there are restrictions in place. And this case is going to be a huge determinant in what the future of college athletics looks like. Is the NCAA allowed to maintain this antiquated concept of amateurism based on dicta from a 1984 Supreme Court case, or will a new decision in 2021 redefine what it means to be a college athlete in the compensation model? And I think we're all really paying attention to the Supreme Court, which no one can really predict what's going to happen. And so I'm excited to see that this change is finally coming to college athletics, something that many of us have been talking about for a long time.
So, Warren, we were talking offline. I think your viewpoints, and the reason we picked you guys in particular, Warren, I think your viewpoints kind of stray a little bit towards, student athletes and making sure they got paid. And I know, Gregg, one of the reasons we wanted to have you on, not that, that you're anti getting athletes paid, but your history in litigation, you do a lot of work on the NCAA infraction level with schools. So you might understand that viewpoint a little bit coming from that level. So just your overall thoughts on the landscape, what we're looking at here, maybe the overall significance of what could occur with also the NCAA.
Sure, I think what's crucial here, Dan, and again, thanks to you and Dan for inviting Warren and I to participate today. As Warren just summarized, this is in a lot of ways a case of first impression, but it really isn't. It's an old concept. And going back to the cases that Warren mentioned, Justice Stevens issued his decision. What's really interesting about that case that Warren mentioned is that the NCAA actually lost that case. And as he used the word dicta, which a lot of people may not really know what that means, basically that means it was not crucial to the decision. It was kind of some ancillary wording that Justice Stevens put into his decision. And that's been utilized, which is an amazing thing. Over the last several decades, most cases that came up have utilized that dicta, if you want to call it, and essentially the NCAA lost in that case, but the NCAA has been able to use that as a defense mechanism, and it's prevented a lot of these cases from going forward until we got to initially the O'Bannon case. And in O'Bannon, it's interesting, we have an O'Bannon and the Alston thing, so people understand it's the same federal court judge. If you want to call it forum shopping, whatever you want to call it, but a lot of these cases that were arising in the Ninth Circuit ended up in front of Judge Wilkin. And then Judge Wilkin made her decisions, and the Ninth Circuit ultimately, with slight modifications, confirmed her decision in O'Bannon, and then did the same thing here in the Alston case. So really what the interesting issue here, and I think all four of us can agree on this, is it's not necessarily presented this way, but what is the line between amateurism and professional sports? Where do we draw that line, and who should be determining that line between amateur sports and pro sports? What makes someone a pro? Someone who plays in the Olympics, they get compensated, they can do endorsements. Are they pros? Well, they're separate. They're distinct from the quote unquote college athlete. So the real interesting thing for all of us who practice in this space, I think more than anything else, is to seek clarification. And what is that clarification going to mean on a go forward basis? And one other point, and then we'll move on to some other issues, is how will this interact with the entire name, image, and likeness concept? You know, the NCAA was going to be dealing with that supposedly in January. They put that off, which a lot of people feel was really because of the Department of Justice letter, who now is going to be a speaker at the table here on the 31st. So the question becomes, where are we headed here? What's going to happen? Are we going to have state laws? Are we going to have federal laws? How will the Supreme Court decision impact either of those two areas? And what will the Supreme Court decision do to the NCAA? And how will they react to it? So you got a lot of columns happening simultaneously, in addition to just the antitrust aspect of the Alston case.
So that's we wanted to get your overall thoughts. And now, obviously we have the O'Bannon in our rearview mirror. We have Board of Regents in our rear view. I just want to kind of frame this, if we were writing a brief or a motion, I'd write the procedural history. And I think it's important to see how we got here. It's no mistake that this has passed through the Ninth Circuit and the same judge that decided O'Bannon. So back in March of 2019, Judge Wilkin decided the NCAA versus Alston case, decided essentially in favor of Alston. That case went up to the Ninth Circuit, was upheld by a 3-judge panel in May of 2020. And now I'm just, the reason, I guess we'll work backwards. Oral argument in this case at the United States Supreme Court is going to occur on March 31st. So it's about a week from today, depending on when you're listening to this podcast. I think it's important, right? Gregg and Warren hit this. This is the first time in essentially 40 years that college sports has been, a topic at the United States Supreme Court level. And that's why, to Warren and Gregg's point, we keep talking about Board of Regents. Both sides keeps talking about it, even though, it's a case the NCAA lost, because there's no other history. So Board of Regents has had 40 years of relevance, and there's a very, likely chance that Alston has that same type of time frame. So just so people are following this, it's very interesting. Dan and I have been obviously keeping tabs on it every subsequent update. October, the petition for writ of certiorari was filed. We had November and December. We had the reply briefs. We had we had some amicus briefs that were filed. But I guess this past week or two, is when we started to have the substantive briefs filed by both sides. And one interesting development that I definitely want to get your thoughts on. We had the essentially the United States government stepping in this case to some extent with the Solicitor General, which I know doesn't happen, and obviously doesn't happen in sports because we don't have that many sports cases. So let's I want to kind of you guys having read the briefs that have been filed by the NCAA. There's been briefs that have been filed on behalf of Alston. What I think is the most important issue to address up front, and then we can take this conversation in any number of directions. I think a lot of people, and myself included, thought that the NCAA was appealing this to the Supreme Court to try to carve out this antitrust exemption, to try to expand on Stevens' dicta and actually get it set in stone. But we read the NCAA's brief, and I think it's been well documented that they are not seeking an antitrust exemption. I'll kick it to you guys. What do you think of that strategy, and what do you think really about how antitrust law plays in this case?
Well, I'll just make a quick comment, which I think is relevant, is, the NCAA, right or wrong, had reached out to the federal legislative body of our country, hoping that they were going to step in and try and provide them with this antitrust exemption that they are so desperately seeking. You know, as they've articulated on numerous occasions, they don't think handling this issue on a case-by-case basis is really going to be productive for anyone. They're looking for some type of directioning, specific antitrust stuff. They initially reached out, and if you look at a couple of the first pieces of federal legislation, antitrust issues were arising, and then the antitrust exemption was addressed. Legislators introduced their bills. It's interesting that the quote-unquote antitrust exemption aspect of it is clearly being rejected. Neither of those parties in the bills that Booker and Murphy have introduced, as well as Blumenthal along with Booker, address that issue in a positive way from the NCAA's perspective. So again, it's an interesting issue. I think right now they're just trying to hope and get some reversion back and sort of get the whole thing reinforced, going back to Justice Stevens and Justice White in his dissent, to trying to get some of those issues that were raised and take them out of dicta almost and make them more relevant if they can. And obviously American Needle, which is another case, which was an NFL case, but interestingly enough, that's only about 11 or 12 years old. Justice Stevens there spoke as well in the majority opinion, and he had some interesting language again there, where he basically, and I'm just looking at my notes to get it correctly, associations or leagues that need to cooperate should not be trapped by antitrust, even though they are subject to it. So again, I think there's this continuing flavor that he continued to offer in his opinions, going back to '84 and then up through American Needle, that the NCAA is trying to embrace and trying to utilize, because again, their biggest fear, no matter what anybody says with the decision that's out there, if it's reconfirmed, are these quote unquote potential internships. And I've heard a lot of people talk to me about this, where that, the extension of some of these benefits that are available through Wilkins' decision, which was affirmed by the Ninth Circuit. One of them, again, is this internship concept. And they're a little concerned about that becoming more of a pay for play idea, which is clearly what the NCAA is trying to avoid from their perspective. They want a line drawn in the sand between amateurism and professionalism, and they're concerned that the pay for play takes it over that line. And again, what is pay for play? Another interesting discussion, and that's their concern that some of these internships, where they're now authorized by the Ninth Circuit, could lead to that.
And I agree with what Greg said. I think, Dan, to answer your question, when you talk about asking for Congress for an antitrust exemption, I think that they still would love one. I think there are lobbying efforts to get one, but I think it's becoming more and more clear under this administration that that is unlikely, that Congress actually drafting an antitrust exemption for the NCAA is unlikely to happen. And so now we turn to what those of us in sports law love, which is some really good antitrust rule of reason analysis, right? I went to law school at Tulane and studied under one of the masters, Gary Roberts, and he was an antitrust law expert working on the Raiders cases for the league. And, let's talk about that for a second, because there's two parts to the Alston case. Number one is a good rule of reason antitrust law sort of analysis, and then the broader picture in terms of what does this mean for college athletics. But when you think about Alston, right, the NCAA received a decision from the Ninth Circuit that said schools must be allowed to offer reimbursements for expenses pertaining to, academic studies, computers, science equipment, musical instruments, et cetera, not included in cost of attendance, but related to the pursuit of academic studies. So that's what the Ninth Circuit decided. The plaintiffs are arguing that the compensation limits are artificially restricting the college athlete compensation model, and without limitations to be able to command greater remuneration for their services. The flip side is the NCAA is making a rule of reason argument, saying that this compensation limit that they've established falls under the rule of reason and passes under the balancing test because they preserve demand for this distinct amateurism-based product of college sports, in contrast to professional sports, in integrating the college athletes into campus community. And that's their argument. And I think what we're finding over time is that this concept of amateurism, this demarcation between pro and amateur, is a blurry line that the NCAA has moved consistently over time to benefit themselves, to stave off scrutiny from antitrust. And what's unique about this, in my mind, and many, is that we've been very clear about what constitutes being a college student. And taking money for signing an autograph doesn't make you any less of a college student in a classroom here at Boston College or anywhere else in the world. And when you look at the entertainment industry, there are students all over the country who are actors, who are musicians, who can go ahead and make money while they're a college athlete. John Mayer at Berklee College of Music, or an actress down at Princeton or Yale. And they can go perform in a show on stage. They can release I'm going to date myself, a CD or an album, something on Spotify. And they can come back into the classroom on Monday, and they can be in the drama club, and they can be in the school band. And the professors don't look at them and say, oh, no, you're a pro. You can't possibly add to the educational experience here at a university. That's just crazy. And so for the NCAA to hold on to this antiquated notion of, well, if you're going to get paid X, you're no longer part of the college environment, I think that's crazy. And the last point I'll make before I get off my soapbox is they've artificially drawn a line, right? It's okay for them to receive all of these benefits for going to a tournament or a bowl game or getting gear or X, Y, and Z. But if I take a college athlete out for a cup of coffee and it's above their school requirements, all of a sudden we have some level of scrutiny that might say, you no longer fall under our definition of amateurism. And there's a great case here at UMass with a tennis player, a mistake is made, $20 is paid, and now a loss of eligibility. This is just crazy. And I think these are sort of examples that when you go back into a rule of reason analysis, the Supreme Court's going to have to figure out about this concept of what does amateurism mean? And are they really protecting something by upholding this cap, which is clearly a restriction of trade? The question is whether it's unreasonable.
And
Right,
I think
Warren.
the other issue, if I could just jump in more to support your point, the other challenge they have is the inconsistent application. And I always talk about this with some of my clients in the labor space. When you're inconsistently applying a rule or a policy, whatever it might be, it really opens yourself up to criticism. You talked about the University of Massachusetts tennis case, and I always juxtapose that with a couple of years ago, and I don't remember her name, I apologize, the female basketball player from Notre Dame, who was very, very successful. And they allowed her to go on Dancing with the Stars and be paid for being on Dancing with the Stars without it impacting her eligibility. And I was just, wait a minute, that's such an inconsistent position to take. And I think that's why there's so much criticism right now, not to mention, this past week or 10 days, the way the facilities were set up, the distinction between the men's tournament and the women's tournament, they just seem to always be stubbing their toe, or perhaps even more than that, running into a wall with self-imposed walls. I mean, a lot of these things could have been avoided, and that's some of what people talk about right now with O'Bannon and obviously the Alston progeny from that. This could have all been avoided years ago if they would have, as you're espousing, Warren, looked at this and made this distinction between, wait a minute, what's the difference between a student athlete signing autographs and getting paid versus the musician who's sitting next to that same student athlete in a history class? And I think that's why so many people have taken this position and are watching this so closely, because of the fact of the NCAA's application of some of these rules in such an inconsistent and as people argue, unfair way.
Yeah, Greg, Warren, I'd like to ask you about the parallel tracks that this case appears to be on with the burgeoning name, image, and likeness legislation that is, being introduced in state houses all across the country. So, one, how does this case and a potential ruling intersect with that issue on the state level? And how would it potentially impact the NIL laws that have already been enacted into being in states like Florida? Is there an impact that this ruling could have on these state statutes?
Well, I think the third column, I'll let Warren go. That's Warren get the right answer. Yes, the interesting aspect of this, Daniel, is I've said it's columns, right? We have the state legislative column that you mentioned. One state going to be effective in July 1 of this year. California potentially considering moving up the date as well. We have Maryland very close to passing it, and we have New York State just reintroduced legislation from the same state Senator Parker that he introduced about a year and a half ago. So you have that state law column, which again initiated and began out in California, ironically enough. where all this stuff seems to be arising from. And then you have the federal column, and we have a multitude of federal bills. And we just saw the most recent bill being introduced by a senator from the state of Kansas, which is interesting because that senator, for the first time, seems to be taking some of the more partisan aspects of Senator Booker's bill and joining with some of the more, what I'll say, partisan Republican aspects of their other legislation. So that's going on simultaneously. And I thought it was interesting when Senator Booker, a few weeks ago at the Aspen Institute, talked about this might go until literally the day before the July 1 initiation effective date down in Florida. So he's sort of playing this out a little bit. I think ultimately it's going to have to be handled in the federal space. But the key question for all of us is, are they going to get to it by July 1? And what if they get to by July 1, what is it going to be and how is it going to look? And then ultimately, the NCAA and all the other schools who are subject to these laws are going to be reacting. If it doesn't happen by July 1, does someone try and move in and try and seek some type of injunctive relief to stop the Florida law from taking place? How's that going to play out? Obviously, the cost there. How does the NCAA react to that? And then we're waiting on the Supreme Court decision, which they're saying is going to come in June. And if we get the decision in June, what's going to happen with that? So again, everyone's going to be in a reactive mode. Right now, there's separate columns that seem to be going independently, right? State laws, federal legislation proposals, the Supreme Court case. But all of a sudden, I think once you get to June 1st or slightly thereafter, a lot of these lines that are operating independently are going to start to cross or crash into one another. And as I look to my friend, Mr. Lust up there as a litigator, it's going to become a litigator's paradise because, again, I do think there's going to be a lot of people moving forward and not just sitting back and waiting. So what happens? We don't know yet. It's going to be interesting to see how it all plays out, but there are certainly multiple things happening at the same time. And a lot of it is going to be contingent upon what the Supreme Court does. Because obviously, if the Supreme Court rules in favor of the Alston parties, that's going to be a big difference than if they rule in favor of the NCAA in their appeal.
So Dan, let me answer that question if I may, but I'm going to take a step back, right? I want to synthesize both of the last two comments and questions, both by you and by Gregg. Number one, these are self-inflicted wounds by the NCAA. There's no doubt about that, right? We could have avoided all of this. In 2011, I testified in front of a subcommittee in Congress, along with Ramogi Huma and some other folks, talking about some of these issues. And one of the things that I was very clear to underscore, as were my colleagues, was that change and reform was coming to college athletics, period. And what the decision that the NCAA needed to make at that point, and this was 10 years ago now, was whether they wanted to enact change that would better address college athlete welfare and the commercialization of college athletics at the major Power 5 schools. Again, there's over 1,000 NCAA institutions, many of which Division III, Division II are not having these issues. But that the NCAA had a choice to either enact some change themselves or have change imposed upon them by legislature and the court system, coming up with a system that may not be ideal for anybody, including those of us who love college athletics but aren't working for the NCAA. So that was something that we've been pointing out for a long time. When you talk about what's happening on the NIL space in states and legislature and federal government and the NCAA sticking their head in the sand in January and punting and all of this stuff, it's a microcosm for how the NCAA tends to work. They want to wait and wait and wait. And all of a sudden, July 1 is going to come. And Gregg is exactly right. Let me be very clear. Name, image, and likeness is coming to college athletics. It's likely to be there this fall. Period. Full stop. Now, under that assumption, and again, that's just my own statement, how much work is being done to address what does that really mean on a college campus? What are all the changes that are going to be happening? Who's going to be paying attention to this? Where are those guardrails that people are talking about? If you're a Nike school and someone wants to sign with Under Armour, if you are allowed to represent alcohol or gambling and all of these different things. And by the way, we have not mentioned, but if you want to see agents start filing their way onto college campus or start recruiting high school students because this particular high school student is going to have some demand at the college level, then all of a sudden you're opening those doors up and are the Players Association's ready for that? And the final statement I'll make on NIL, and we haven't really talked about this in terms of who's really going to benefit. I actually think that it's really a small number of sort of high profile athletes will generate some real money. But I also think that there's going to be a lot of opportunity for some of these underrepresented sports, women's ice hockey, for example, here at BC. We have a lot of players who have been or are on the Olympic team, right? The ability for them to run a camp over the summer is going to be fantastic. Not everyone on the football team is going to make a lot of money, but there are going to be some individual folks, women's tennis or men's tennis and golf, giving lessons. These are things that they are restricted from doing that they would be allowed to do moving forward. And I don't know if that answers your question, Dan, but I think that the NIL situation is really a microcosm for the NCAA's inability to think through the ramifications of this tidal wave of change that's coming their way, and continually sticking their head in the sand and just hoping that this throwaway line from Stevens in 1984, which talks about preserving amateurism, would become this final shield against everything that was coming their way. And it's not going to save them.
And I think the other interesting point, Daniel, about that is, as Warren was just touching on, is, the NCAA, they do put their head in the sand, but it'll be interesting to see if nothing is passed by July 1, and all of a sudden you have Florida and perhaps some other states are going to move up as they pass some legislation over the next couple of months. How is that going to impact like a school like Boston College? So, for example, if they don't have NCAA modifications to their bylaws by that time, but there are state laws that are impacting them. So, for example, BC is in a conference. Are they in a conference if Massachusetts doesn't pass a state law? Are they in a conference that has other states that pass NIL legislation? And how does that impact them from a recruiting perspective and securing athletes? And then also, if it is in a state where you pass the law, who's going to be responsible for enforcing that law on the NCAA and on a campus, which is an NCAA bylawed campus? Are schools going to have to hire additional compliance people or add additional duties to the current compliance people to make sure they are in compliance, as Warren said, with some of the state nuances about whether or not you can wear, for example, if the school's a Nike school, but the young athlete has an opportunity to wear Under Armour in a classic ambush marketing case, is that permitted? What's going to happen? Who's going to be enforcing that? A lot of these issues are going to come down on the campus level as well.
So a couple of things, and actually, while we're on the podcast, we had some we'll call it breaking news for us. We're all interested in it. Oregon is proposing a bill that would allow name, image, and likeness to come into effect July 1st. So it's just another.
You're going to see a lot more of that.
And I'll bet you that Nike's behind that, but
it makes sense.
No, come on, Warren, never.
There's a lot of people, and this is Dan and I have had in the past 2 weeks, 3 weeks, state senators that have come on the podcast talk about sports betting, but name, image, and likeness in the same context. People want their names attached to these bills, right? So one of the few things in our country that's a bipartisan issue that, for better or for worse, right? I don't really necessarily agree with it, but we don't have sports betting in certain states because senators are fighting over should colleges be in it, should pros be in it, so they're fighting over minutia. Now, Warren and Gregg, it's funny on this case. I was talking to a colleague yesterday, and we're having a very high level antitrust conversation, how it's going to impact name, image, and likeness. And we're all talking kind of like unvetted name, image, and likeness, right? What the version of fair pay to play, where athletes can make money from endorsement deals and whatnot. This case, at least as I read Judge Wilkin's decision, I'm just going to read kind of a quick synopsis. Judge Claudia Wilkin, held that the NCAA violated antitrust law by capping grants in aid to tuition, fees, room, board, books, and other expenses up to the full cost of attendance, and that colleges can't collectively decide that they won't reimburse expenses related to education, e.g. computers, musical instruments, and incentive awards. So for me, as someone, right, like let's say I didn't know the whole backdrop of the NCAA and I didn't know that they're fighting for, antitrust protection. I look at this case and it seems to be like a pretty narrow issue, right? It's just talking about capping grants for tuition, room and board, and reimbursements on computers. How do we get from what seems to be a relatively narrow holding, right, with Sean Alston as a former West Virginia football player? How do we get here, right? And to Gregg's point, I love this comment, separate columns. I don't think name, image, and likeness is fully on trial with SCOTUS. I think it's something ancillary, it's something similar, but we're having a conversation about full name, image, and likeness. How do we go from what seems to be a narrow area, right? They're challenging to this larger concept of NIL. How do those two things fit together?
Well, I think the challenge you're facing is, initially the criticism of Judge Wilkin is that, a term we learned in law school years ago is that the concept of stare decisis, is the fact that she is on her own rewriting and reinterpreting a Supreme Court decision. Now, of course, the flip side of that argument is no, she's not, because as Warren said from the very beginning, that was really dicta. That was not really substantively part of the decision, which actually went against the NCAA. So, I think that's the first issue where this whole dispute seems to be focusing on, is whether or not did she have the authority to overrule a case. And if you look at the submissions that were made by the NCAA, I can't tell you, I didn't add it up, but I can't tell you how many times they added and referenced Board of Regents in their submissions in terms of support of their presentation coming
Can I
in.
stop you for 1 second, Greg? Because I think it's important to point out, and you guys, we hit on this. Alston is a West Virginia running back, right? He didn't play for UCLA. Ed O'Bannon played for UCLA, so it was a logical, that it would end up in a California court. It would end up in front of Judge Wilkin. It would go to the Ninth Circuit. I think it bears mentioning, right? This seems to be a little bit of forum shopping, that Alston got this case in front of Judge Wilkin. When we talk about stare decisis, Judge Wilkin's kind of bound by her own prior precedent. So I think it was a really smart tactical move on Alston's part to get it here. I think that's
absolutely
the equation.
Forum shopping has been part of sports law for decades, right? I mean, Judge Doty in Minnesota has been the NFL, and the PA's, judge for forever. And so, there's nothing untoward to that happening. So,
yeah, pretty obvious. That's what was going on here, Dan. And you know what? As Warren was just saying, historically, we've seen that, especially in the sports law space, where they go back to the same spot. And, typically they have the ability to forum shop because of the issues that they're dealing with are such that they can be essentially venued in multiple locations. So, but that's been the big issue, is whether or not she went too far. But as you said, in O'Bannon, she took care of it. But now the question is, did she modify that and go too far here in the Alston case? And then ultimately, how does any of the stare decisis from the Supreme Court decision apply if, in fact, there is some basis for it other than an addictive space? So the bottom line, that's really, if you put the polls up, that's the two arguments on separate issues. One is the NCAA, as Warren said, and I couldn't agree with him more, is trying to hold on to an antiquated concept, something they've ignored for years, that if they wouldn't have ignored, I don't think we'd be in this situation. One of their arguments they're trying to appeal on a sympathetic basis is that, this issue is going to be handled by multiple lawsuits on an ongoing basis, and we should have some deference as the experts in this amateur space to decide who's an amateur and who's a pro. So ultimately, the other question becomes, do we want the NCAA deciding that and making those decisions? And if you look at them historically, a lot of people will say, no, we don't trust them. We don't think they are necessarily the right body to make that decision. And then the flip side is, yeah, but do we want to have a multitude of lawsuits all over the country that the NCAA is faced with defending and spending? They've already spent tens, if not hundreds of millions of dollars. We want this to continue. So we need some decision making. We need some definition as to this distinction between amateur and professional. And unfortunately, because of the way it's been handled, it's been all over the place, as Warren said. We've had multiple cases going in different directions.
And Greg, I've got one of the things that we haven't talked about, we're here in 2021, right? And we are hopefully at the end of this pandemic. And I think that's going to color some of the decisions moving forward, right? So the NCAA has been arguing about student welfare and maintaining the integrity of college athletics as part of a college experience for these students. And that's so critical. And if we paid them or let them, get paid for autographs, that would blow this up, because that would be commercial in nature. And we want to protect this line of demarcation that they talk about in their mission statement. Well, look at March Madness. Look at what's happening now as college athletes are traveling to play basketball, to generate revenue for college athletics during COVID, during this scare. And so I think to some extent, this ability for the NCAA to argue it's all about student welfare and this line of college athletics, I think that because of the pandemic and because of what we've seen with colleges trying to maintain this level of revenue, I think that takes away a little bit of their higher ground statement about, no, this is all about amateurism and education. You can't tell me, like, I understand the value of playing sports in college, right? It teaches transformative skills. You can't recreate in the classroom, et cetera. But you can't tell me that playing basketball in a gym in front of 100 people is a worse educational experience than being locked down in a hotel to play basketball on television so that money could find its way to a conference.
Couldn't agree with you more, Warren. And that's one of the things in the one of the final submissions that was made to the court in the last couple of weeks. That was one of the issues that I know the Alston team presented, was this inconsistency. They're talking about protecting student athletes and all those things, and yet here they have them traveling and playing away from campus in the middle of a semester, essentially quarantined and locked in hotel rooms without any ability to do other things. And again, is the educational experience being benefited by sitting in a hotel room, really based upon the desire to get through this tournament and ultimately, I hate to say it, generate the revenue that the NCAA so desperately needs because the 2020 tournament was canceled.
Dan, we'll edit this. You're on mute. Oh, we'll edit this part out. You're on mute.
Okay, sorry, I was on mute.
Just pretend like you weren't on mute.
Okay, Warren, Greg, in the waning moments we have left on the podcast, let's talk about the range of possible outcomes. Now, the Supreme Court did not grant cert in the O'Bannon case. The Ninth Circuit does have the statistical reputation of being the most heavily reversed, or one of the most heavily reversed circuit courts in the country. I think the number that I've seen is 78%. The Supreme Court is now, leaning even more conservative than it has been previously. How much does the composition of this court, in your mind, play into the likelihood of an NCAA victory here? And is that how you would handicap the possible outcome? And what are the ranges of possible outcomes here? Both win and loss. How do you see this case possibly shaking out when we do get a decision from the court?
Well, let my favorite professor go first.
I was going to say, I'll let you go first.
Okay. All right. Well, I think it's interesting because clearly, as we've been talking a little bit here about name, image, and likeness, which is really not a subject of the Alston case itself, there's a lot of things that are intertwined here that'll be impacted by this decision. One of the things I said from the first day, as you correctly just said, Daniel, where the O'Bannon case was not granted cert, I said, that's interesting. They granted cert here. They're not granting cert, I don't think, to just sort of smile at everybody and say everything's good. So they're going to do one of two things here, right? They're going to go backwards or forwards. They're going to revert back to Justice Stevens and try and say that was not clearly dicta and try and apply some of the themes in there of this distinction between amateurism and pro. And again, keeping in mind from the 1980s when that decision was made, that distinction between amateur and pro is really, really changed a lot. So whether or not some of those highlights that Justice Stevens pointed to there in American Needle are still appropriate, we're going to find out, I think, pretty quickly. Obviously, the flip side is if the NCAA wins, what are we going to see? We're going to see, I think, more of a regressive tone. And I know everyone said it was the Department of Justice letter that stopped them from making any of these bylaw modifications addressing name, image, and likeness. Part of me thinks it was really delayed because they wanted to see what the Supreme Court was going to decide. And they had to figure out some way to, quote unquote, stall this decision because they had promised something in January. So the Department of Justice letter was a little bit of perfect timing for them. So you're going to see two things. One is you're going to see the extreme where they're going to be forced to react, or the other thing is going to be, perhaps, as I said, a reversion back to some older standards, which will not be, I don't think, for good for anybody.
So, that said, again, we mentioned oral argument, March 31st. We didn't touch into it. Dan and I will explain it, but the Solicitor General is popping in here. This is a very, I don't know, not a typical situation, and one that will obviously be, in the sports law history books for some amount of time. But Greg, Warren, any parting thoughts as we put this in the books?
Tune in on March 31st.
Yeah, I would agree. I think that history is going to be made both watching the oral arguments and then the decision. I do think that we are headed for change, and I think that if to play off what Greg said in terms of the decision, I think it's really hard to predict. Right, we certainly have a quote conservative majority at the Supreme Court, but these also could be business-friendly justices who make a decision that would benefit the athletes in free market as opposed to the NCAA and restraining trade. So I think it's really hard to predict what they're going to do, as would almost every Supreme Court case. But I also think that the other thing that's sort of happening that we haven't mentioned at all when you talk about college athletics is other alternatives for elite athletes, right? If you're basketball, player, you now have other places you could potentially take your talents to generate revenue. And I think that will play a role in what college athletics looks like if, depending upon the NCAA decision or the Supreme Court's decision on the case, if they uphold some of these levels of amateurism, then you might see more elite players going and getting paid for a year before they enter the league. If they release those restraints at the college level, then some of those alternatives, because college isn't right for everybody, may become less appealing. So I think that either way, we're going to see a very different college basketball environment in a couple of years.
Great point.
Yeah.
And I guess I should say,
Warren,
Dan and Greg,
you
thanks for the time.
Yep. No. Thank you and for Greg for shining a light on this complicated subject matter and breaking it down into, I guess language and words that we can all understand, because that was one of the reasons I chose you. You both have been really fantastic communicators in the sports law space. And I wanted, with law professors, it could be focused more on the academic side of it. And I wanted practitioners, and I wanted somebody who was sort of like, in the trenches in collegiate sports. And I think we have, through you and Greg, Warren and Greg, we have like the perfect, blend of voices to kind of overview this important topic as we await oral argument in a couple of days. So Warren, thanks for your support back in 2015. I don't think I would have gotten through that experience without you. I think that was one of my better panel experiences, and you definitely, made me, relaxed me a little bit and gave me the confidence to succeed. And Greg, I can't think of between you and your partner, Paul Kelly, to the most super people, nicest, people in the entire sports law space. And the three of you have made me feel so welcome. And as a neophyte in my 50s, to go from, sort of the world that I had occupied in appellate law and litigation, where it was really tough to sort of like crack the old boys network, to being made to feel so welcome in my first ever, conference. And you guys have been so consistently nice to everybody that you've been, that you've come across, that I wanted to really have you back on, because it reminded me of one of the most positive experiences I've ever had in the sports law space. And you guys hit it out of the park tonight or today. So thank you very much. And we'll check back with you, obviously, in a few days after the Supreme Court oral argument to see what you guys thought of the argument and which way it's going to, tilt.
Thank you, Daniel.
Yep, wonderful. And thanks, Sam. We'll send you our invoice.
Sounds good. Send it to Wallach, not me.
Absolutely.